Liani Reeves is new to us this year, and she's been a great addition to the firm. She has lots of experience in employment defense and training and prevention strategies as a former general counsel for the Office of the Governor. Liani's materials you can find behind tab 5 in your materials, and we're now going to screen her latest production, Recent Local, State, and Federal Legislative Developments. As an introduction to her presentations, we hope you will enjoy this teaser from a classic, Mr. Smith Goes to Washington.
It's dawn. Your bill is ready. You take it over there and introduce it.
How?
You get to your feet in the Senate, take a long breath, and start spouting. But not too loud, because a couple of the senators might want to sleep. Then a curly-headed page boy takes it up to the desk, where a long-faced clerk reads it, refers it to the right committee.
Committee, huh?
Committee.
Why?
Look, committees, small groups of senators have to sift a bill down, look into it, study it, and report to the whole Senate. You can't take a bill nobody ever heard about and discuss it among 96 men. Where would you get?
Yeah, I see that.
Good. Now, where are we?
Some committee's got it.
Yeah. Now, days are going by, Senator. Days, weeks. Finally, they think it's quite a bill. It goes over to the House of Representatives for debate and a vote. But it has to wait its turn on the calendar. More amendments, more changes, and the bill goes back to the Senate. The Senate doesn't like what the House did to the bill, they make more changes. The House doesn't like those changes, stymie.
So?
So they appoint men from each house to go into a huddle called a conference, and they battle it out. Finally, if your bill is still alive after all this vivisection, it comes to a vote. Yes, sir. The big day finally arrives, and Congress adjourns.
Good morning. My name is Liani Reeves. I'm new to Bullard Law. I started in June of 2015. I'm really excited to be here. This is my first annual briefing, and I'm really honored to be here. Thank you for having me. So Mr. Smith had a lot of disappointment. I am going to try to raise the tone a little bit and give you an overview of some federal, state, and local action. It's hard to follow a presentation with slides of kittens, but I'm going to do my best. So here's what we're going to talk about. A little bit about federal, what's happening on the federal side. A lot of this presentation will be on state laws, specifically in Oregon, and this flagging some local action. And I should say that this is going to be a very brief overview of lots of different topics. It's really to flag for you as employers some issues that you should be reviewing policies and training your staff if they're new to you. But we're not going to be drilling down really on the mechanics of the laws. It's more of a broad overview and sort of a snapshot of things that you should be aware of. So turning to the federal side, not a lot of action. There is a lot of disappointment and a lot of dead bills. A lot of Mr. Smiths are very disappointed in Washington. Just to sort of give you a flavor of what's going on the federal side, last year there were 163 congressional bills dealing with labor and employment. 2 of them made it to signature by the president. And before you get super excited about what those 2 are, let me tell you what they are about, and you can see if they apply to you. One, quote, makes technical corrections to several drafting errors in the Workforce Innovation and Opportunity Act, so not very substantive. And the other one has to do with reducing a scheduled increase in minimum wage applicable to American Samoa. So if any of you have employees in American Samoa, come see me after the presentation. Otherwise, we can sort of ignore what's happening in the federal Congress. I am going to talk, though, since Congress isn't acting, the White House has decided to take a few measures into its own hands. So I'm going to talk about a couple of executive orders that the White House has issued. Paid sick leave for federal contractors, minimum wage for contractors, and amendments to the Equal Employment Opportunity executive orders. If you have employees or if you contract with federal government agencies, these may apply to you. So I'm just going to flag these for you. The first one is Executive Order 13706. It's effective January 1st of 2017, and it provides that new contracts with the federal government must include a clause that all employees shall earn not less than 1 hour of paid sick leave for every 30 hours worked for up to 56 hours of paid sick leave per year. So the Department of Labor will be issuing regs by September 30th, 2016, so you'll want to stay tuned for those. So if you hold federal contracts, you're going to want to review Are your contracts subject to the executive order? Because not all contracts are, so you're going to have to review that. And you're going to want to look at whether or not you're going to have to modify your leave policies to comply with this particular executive order. Executive Order 13658 is already in effect, so hopefully people already know about this, but it's an increase in the minimum wage for federal contractors. The increase in the federal minimum wage hadn't been raised since 2009. It was at $7.25 an hour. This executive raised it substantially to $10.10, and for 2016, the minimum wage is going to be increased to $10.15 an hour. The last executive order I'll talk about is 13672. This one took effect April 8, 2015, and it's part of a larger trend of the federal government in terms of incorporating sexual orientation and gender identity into all of their protections. So this particular executive order updates previous orders to say that anytime there's an anti-discrimination clause in a contract, you have to also include sexual orientation and gender identity into those particular contracts. So anywhere you have a contract with the federal government that has the "we will not discriminate on the basis of race, gender," you now have to make sure gender and sexual orientation language is also included in that contract. This applies to contracts entered after April 8th of 2015, so going forward. And just a couple of definitions. Sexual orientation is an individual's physical, romantic, and/or emotional attraction to people, regardless of whether it's the same or the opposite gender. And then gender identity is one's own internal sense of gender, which may or may not correspond to that which was assigned at birth or visible to others. So this is, just part of a larger federal trend. The EEOC has been very aggressive in enforcing discrimination cases based on sexual orientation and gender identity. OSHA has also been fairly aggressive in promulgating some advice on protections for gender identity individuals. So this is definitely a trend in the federal side of things, so you'll want to make sure that you're updated on that. So turning to the state, we have a happy bill. It seems where the federal Congress has been stalled, states have been taking action. So just sort of an overview to show some hot topics. Minimum wage is a hot topic. At least 25 states changed the minimum wage in 2015. Like we're going to talk about in Oregon, paid sick leave movement is definitely a hot topic. There's now 4 states, the District of Columbia, and at least 17 cities or counties that require paid sick leave. And then there's also been some movement around additional protections to non-employees such as interns and volunteers. So turning to the state level, I'm going to talk about these bills fairly quickly, but paid sick leave, wage discussion protection, social media protection, ban the box, OFLA amendments, domestic violence leave, domestic workers protections, and enforcement of non-competition agreements. So the Oregon legislature in 2015 was fairly busy in the employment sense. These are just some of the bills that I'll talk about. There's a briefing memo that was done and posted on our website and also available copies outside, sort of a more comprehensive overview of what happened in the 2015 legislation produced by our office. You can pick that up. So Oregon paid sick leave. Again, we're not going to drill down on all the specifics, but let me flag for you what it is. It's effective January 1, 2016, and it provides that all employers with employees working in Oregon must provide legally protected sick leave to qualifying employees. There are many, many amendments. There's over 40 proposed amendments. There are lots of political trade-offs to get this bill passed, but at the end of the day, this is what it provides. So any employer with 10 or more employees working in Oregon must provide paid sick leave. Portland has a specific carve-out because they had already enacted a local ordinance, so they are trying to preserve some of that ordinance. So Portland employers with a business in Portland, if you have 6 or more employees, must provide paid sick leave. All other local sick ordinances are preempted, so Eugene enacted a local ordinance around paid sick leave. It was scheduled to go into effect mid this year. They suspended it, and it will be automatically repealed when the Oregon paid sick leave law goes into effect in January. So if you're under 6 employees, all other employees in Oregon, employees in Oregon must provide unpaid sick leave. So you're looking at 6 or more if you're in Portland, or 10 or more for the rest of the state. Which employees are covered? All employees, full, part-time, or temporary, paid by hour, salary, commission, or piece rate. Those who perform work in Oregon, and it applies to all private and public employers except the feds. So large body of most people are going to be affected by paid sick leave. So again, not getting into the mechanics, but the things that you're going to want to do to make sure that you're complying with the paid sick leave is you're going to have to look at your accrual systems and make sure that they can accommodate accrual at the proper rate. You're going to have to look at your payroll systems and make sure that they're in effect with your accrual systems. You might have to update your policies and practices to be in compliance, and you might have to create new policies to help bring yourself into compliance. The next law I'll talk about is House Bill 2007, effective January 1, 2016, and this provides protections for employees who want to talk about their wages. It makes it an unlawful employment practice for an employer to take a negative employment action based on an employee inquiring about his wage or discussing or disclosing his wage information or her wage information about him or herself or another employee. And it also makes an unlawful employment practice to retaliate based on that protected activity. It does not protect, of course, unauthorized disclosure. So if you have somebody who has access to wage information as part of their jobs and they make an unauthorized disclosure of that information, that is not protected. But what is protected is generally people talking about their wages in the workplace. So this protection may sound familiar to you because under the National Labor Relations Act, Sections 7 and 8, it prohibits most employers from retaliating against employees who discuss terms and conditions of their employment, which may include the terms of pay with other coworkers. So some of you are generally familiar with this type of protection. However, House Bill 2007 applies more broadly. It applies to all employees, including employees in supervisory, managerial, and executive positions, whereas the NLRA does not apply to that category. And it also protects just mere inquiries into wage information rather than full-on discussions or disclosures of wage information. So the protections under 2007 are a little bit broader. So in order to comply, you're going to want to review your work rules and confidentiality policies to ensure that this type of conversation and discussion is not prohibited. You're going to have to want to train your human resources and other supervisory managerial personnel to ensure that they know how to manage those types of discussions in the workplace. Social media protections. So we already had fairly robust social media protections in the state. Senate Bill 185, effective January 1st, 2016, adds a few more protections. This applies to all forms of social media, from Facebook to Twitter, and a bunch that I don't actually know what they are. But there's lots of different forms of social media. This is what the current law prohibits. You can't require an employee to disclose your username or password. You cannot force an employee to allow the employer to view your Facebook page or other social media account. You can't force an employee to friend you on Facebook, and you can't take a negative employment action if an employee refuses to do any of those things. So the new protections include, you cannot require an employee or applicant to establish or maintain a personal social media account, and you cannot require an employee to advertise on his or her social media account. And it sounds kind of silly, but I think it comes up more often than you would think, especially in the professional context. For example, LinkedIn is a professional networking website, and if you join an employer, the employer might say, hey, we need you to update your profile information to say that you're now an employee of X corporation and link to our page. That's now prohibited under the law. So in order to come into compliance, obviously any practices that require an employee to advertise or link to an employer or to have or maintain a social media account needs to cease by January 1, 2016. Ban the box. House Bill 3025, effective January 1, 2016. This makes it an unlawful employment practice for an employer to exclude an applicant from an initial interview solely because of a past criminal conviction. So you can't even ask the question, do you have a criminal conviction, prior to the interview stage? Or if it's a job where there is no interview stage, you can't even ask that question prior to an offer of conditional employment. Now, there are some exceptions, of course. Law enforcement agencies and employers in the criminal justice system can still ask that question. So you're going to want to determine if you're an employer that fits within those categories. And if you're hiring non-employee volunteers, you can still ask about criminal background. And some of the takeaways, it is a limited type of ban the box. Employers can still decide not to hire an applicant if they have criminal convictions, and they can still ask about that in the interview stage. They just cannot ask about it prior to an interview or a preconditional offer of employment. So in order to comply, you're going to want to review all your applications, whether they're paper or electronic, to make sure that you're not asking questions that you can around criminal history. If you're an employer that plans to ask about criminal convictions in an interview, you'll want to produce some sort of form that includes a signed by the applicant and the date and sort of an acknowledgement that the question was asked at the proper stage of the process. And you're going to want to train personnel who are interacting with potential applicants to make sure that they're not asking questions or seeking information that violates this particular provision. There were some amendments to the Oregon Family Leave Act, House Bill 2600, effective January 1, 2016, and this requires a continuation of group health insurance coverage for an employee on family leave under the Oregon law. If you're a federal FEMLA-covered employee, this is not going to be a particular change for you, but if you're an employee in Oregon, an OFLA-covered employee, but not a FEMLA-covered employee, so 25 or more employees, and you provide a group health plan coverage, you're going to be required to continue offering that same coverage under the same terms while the employee is on family leave under OFLA. Now, if you require an employee to make contributions, you still can do that, of course, but this is requiring coverage of the group insurance plan, group health plan, whereas it wasn't covered under OFLA before. So again, it sort of aligns OFLA and FEMLA, and so really the biggest impact is to employers of between 25 and 49 employees, people that were covered by OFLA but not FEMLA. So if you're one of those employers, if you have 25 to 49 employees, you're going to want to look at this particular bill and figure out how to come into compliance. You're going to have to review your policies and your procedures around your continuation of coverage and make sure that that continuation the coverage continues under OFLA. Senate Bill 492 provides additional protections for domestic violence leave, which includes leave to handle matters related to domestic violence, harassment, sexual assault, and stalking. So right now, employers are already, and this applies to employers of 6 or more, employers are already required to allow employees to take vacation or paid leave. This adds sick leave or personal business leave to the types of leave that employees need to be allowed to take if they're going to be leaving to deal with these types of matters. The employee's leave must still be reasonable, and the employer can still limit the amount of leave if the absence is creating an undue hardship on the employer. But in order to comply with the law, you're going to want to review your policies to provide for all protected leave related to domestic violence, harassment, sexual assault, and stalking, and that the policies allow the employee to use any form of available paid leave, sick leave, or personal leave in order to deal with those particular matters. Domestic workers, this is a new type of protection. Senate Bill 552, there was a gap in protection for certain classes of workers, and particularly in the domestic worker field. So domestic worker is defined as one who works in the home of another person for the purpose of caring for a child, doing housekeeping, or providing other domestic services. There's a long list of people that are categories of employees that are excluded from the definition of domestic workers, so you'll want to take a look at that. But if you're employing family members, if you've got high school babysitters, babysitters under the age of 18, casual laborers, independent contractors, people who are coming in to fix your drain, house sitters that do not perform domestic services. So there's a lot of people that don't actually fit under the domestic worker category, but there's also a large category that does. So if you employ domestic workers, you're going to want to take a look at this bill. It establishes workforce protections for domestic workers, including the right to overtime pay, requirements for time off, allowance for food preparation, and paid personal leave based on an employee's average weekly hours in the previous year. It also provides protections for domestic workers, such as bars the employer from requesting custody of an employee's passport. This is obviously sort of a move against the trafficking issues, trafficking and domestic servitude issues, making unwelcome sexual advances, intimidating or otherwise creating a hostile work environment, harassment, and then it provides for retaliation. Domestic workers can sue for retaliation. BOLI is in the process of promulgating rules on these particular laws, so stay tuned for those. Non-competition agreements. This is just sort of a a change in the length of enforceability. So House Bill 3236, effective January 1, 2016, the current enforceability of non-competition agreements is limited to 2 years. Oregon already disfavors these types of agreements. The legislature has chosen to disfavor them even more. They've decreased the amount of time of enforceability from 2 years to 18 months. So in order to comply, you're going to want to look at all of your forms of non-competition agreements to make sure that instead of 2 years, it says 18 months for any agreement entered into in January 1, 2016 or later. And you might also want to consider whether a non-solicitation agreement, which prohibits a former employee from soliciting your clients, whether or not that would meet your employer's goals instead, because non-solicitation agreements are not subject to the same types of restrictions as non-competition agreements. Just a brief overview of some California laws for those of you who have employees south of us. California has also been looking at gender wage issues. Senate Bill 358, which is effective January 1, 2016, places a higher burden on an employer to prove that a man's higher pay is based on factors other than gender. It provides a right to sue if an employee is paid less than someone else who does substantially the same work but has a different title. So trying to address the gap in gender disparity pay. It also protects employees from discrimination and retaliation if they ask questions about how much other people earn, similar to Oregon's new law, House Bill 2007. So that's Senate Bill 358. Assembly Bill 1506 makes some changes to the California Labor Code, which requires employers to provide wage statements to employees. There was a practice of just technical problems in the wage statement would create a private right of action for an employee to sue for civil penalties. It now provides that employers have 33 days to cure a technical violation of those statements before an employee can bring action for civil penalties. A prohibition on the misuse of the E-Verify system, which verifies employment status, legal employment status under the federal system. So right now, some employers are required to use E-Verify, either because they receive federal funding or it's some kind of federally mandated practice. Assembly Bill 622 says employers can no longer use that system if they are not required to use that system, and it actually provides that employers could be fined $10,000 per violation if they check the employment status of somebody that they don't need to check the employment status of. And then the last one, Assembly Bill 970, provides expansion of the Labor Commissioner's enforcement ability over local overtime, minimum wage, and overtime laws. Currently, the Labor Commissioner only has statewide authority. So I flagged some of these California issues because, again, it shows sort of trends in what states are looking at in sort of the absence of federal action. Talking a little bit about local action in the state, I'm going to talk about Senate Bill 968, which was a statewide bill that actually preempts local action in certain areas. And then, again, to look at the trends of what the counties are and then sort of the local action is going on. And we look at the Multnomah County Parental Leave, which is brand new, the Portland Minimum Wage, and the Portland Sick Leave, which we've talked about a little bit. So Senate Bill 968 is effective for a short period of time from June 25th, 2015 to August 31st, 2017. And what this is that both the state legislature and some local governments were looking at potential laws that would require employers to schedule a certain way. So it would require the employer potentially to obligate the employer to accommodate schedule changes, not based on medical leave or not based on other protected status, but just a general obligation to help employees with scheduling requests. None of those bills passed, and as part of the compromise to get the sick leave bill passed, the state legislature enacted Senate Bill 968, which says local governments, you can't legislate on this issue for 2 years. That will give the state some time to figure out if we want to legislate, and then after that, either we will have legislated and preempted it, or maybe we have done nothing. But until August 31st, 2017, local governments are prohibited from regulating how private employers schedule their employees. Portland was looking at this particular issue, and obviously they won't be able to do anything until August of 2017. Multnomah County Parental Leave, this was just adopted October 8, 2015, effective November 1, 2015. Multnomah County is the first government in Oregon to grant parents this type of leave. It only applies to county employees, but I wanted to flag it because it may show some sort of trend. But basically, it provides that Up to 6 weeks of paid parental leave be given to employees beginning November 1, 2015. It applies to all regular, probationary, and limited duration employees who have worked at the county for up to 180 days prior to the time they go out on leave. And employees who work less than 40 hours a week will receive a prorated amount. So this is something new that the county is doing. Obviously, it's a fairly significant movement for the county, and it'll be interesting to see if other jurisdictions follow suit. Portland minimum wage. So Portland minimum wage adopted a resolution on July 1st, 2050, raising the minimum wage for city contractors and full-time workers up to $15 an hour. So this applies to city workers and city contractors. There are a number of people that are not eligible under the minimum wage, but it was raised to $15 an hour from $10.10 was what it was at. And then Portland sick leave we've really talked about already, and I only flag it because this is what's in effect until December 31st, 2015. And this applies to full-time, part-time, and temporary employees who have worked at least 240 hours for an employer, and you accrue 1 hour protected sick leave for every 30 hours work. And this is where that 6 or more number comes in. Under the Portland sick leave ordinance, paid sick time for employers is required for employers with 6 employees or more, and unpaid sick time is required for employees of 5 or less. An employee may accrue up to a maximum of 40 hours of protected leave a year. Again, this is only in effect until January 1, 2016, at which time Portland employers are going to want to look at how to amend their policies to comply with the statewide sick leave law. And as I said earlier, the Eugene sick leave ordinance will not go into effect. So that is my very brief overview of what's happening sort of around the state and just some trends, and I appreciate your time. Thank you.